Good morning and welcome to the sixth meeting in 2021 of the Finance and Constitution Committee. We received apologies this morning from Jackie Bailey, and James Kelly will be attending as a substitute. Apologies also from Anna Sarwar. The first item on our agenda today is to decide whether to consider our draft budget report in private at future meetings. Are members agreed? And I'm guessing that members are agreed. So we now move on to our evidence session on the impact of Brexit on devolution. We're joined for this item by Mike Russell, MSP, who's the Cabinet Secretary for Constitution, Europe and External Affairs, along with Scottish Government officials David Barnes, who's the Deputy Director of the EU Exit Strategy and Negotiations, Ewan Page, who's the Head of UK Frameworks, and Chris Nicholson, who's a Solicitor and Head of Constitutional Reform and External Affairs. I warmly welcome our witnesses to the meeting this morning and invite the Cabinet Secretary to make any opening remarks that he would like to do so. Cabinet Secretary, over to you.
Thank you very much, Convener, and thank you for the invitation to be at the committee again. I don't know whether this will be true, but this may well be my last appearance at the committee in the current session, and indeed, as I'm not standing again, perhaps in any future sessions. So thank you for having me here on this occasion. I don't think anything I have to say will be a great surprise to anybody at the committee today. I have been appearing at committee regularly over the last few years. The Brexit deal agreed by the UK government is a bad deal. It will remove Scotland from the European single market and the customs union against our will, hitting jobs and the economy at the worst possible time. The post-Brexit relationships with the EU could have taken any number of different forms, but this is very nearly the worst form, and it was the result of a conscious political choice by the UK government, and as I said, firmly against the wishes of Scotland. Of course, leaving the EU fundamentally changes the UK as a state. The UK is shorn of the EU's negotiating power and the expertise, and it will shine a spotlight on the inadequacies of the intergovernmental arrangements that exist within these islands. Clearly, my own preferred solution is well known to the committee. But even if that is not a solution that is held by all members of the committee, there can be no doubt that there are required to be fundamental changes in the structure of devolution. Regrettably, the UK government does not seem to understand that, but instead appears to be keen to diminish devolution in order to further centralise control. Significant changes will be required, for example, in the areas of international treaties, because there are areas of devolved competence which are actively being discussed with others as the basis of those trade treaties. It is important that the Scottish Government is heard as the UK government develops international ambitions, so that we're not simply dragged along in a series of what you might call strategic imperialist visions, but actually think about our position as a small country in Europe. We need robust governance structures that include dispute resolution mechanisms, so that we know with confidence how we can do business. And there is also a range of other issues that require recognised, including a very important issue, alignment with EU priorities and regulations. The Internal Market Act pushed this whole issue in the wrong direction. It was an assault on devolution, and it makes it difficult to see how we can get to the type of agreement we wish to have. And the work that should be going on to produce a new intergovernmental review has by and large stalled, with the UK government not willing to move on the key issues that still require resolution. These are all matters I'm happy to talk about and to discuss. There are issues of the frameworks, of course, that can also be considered. But I hope that gives an indication of where at least I'm coming from. As I say, it won't be a great surprise to members of the committee, but I'm happy to discuss it with them.
Thank you, Cabinet Secretary, for your opening remarks. I want to come to some of the alignment issues in a moment, but first of all, it's now 6 weeks since the Trade and Cooperation Agreement came into force, and we've seen issues arise in areas such as fishing, rising costs for consumers, some significant logistical challenges. The UK government contends that these are teething problems. But what are your views on the impact of the agreement on the Scottish economy? Are these teething problems, or are they more systematic or systemic, should I say, and long-lasting?
I think it's interesting that even the UK government has stopped referring to them as teething problems. I think they recognise the reality of this situation. And the reality is this. The relationship between the UK and the EU has changed, and has changed, as far as we can see, permanently. And that the UK is now a third country. So its means of doing business with the EU is the means of doing business as a third country. And that inevitably, and indeed, not only I have been saying this for the last few years, but every commentator has been saying this, inevitably, that would lead to a change in how business is done. A third country does not have access to the single market in the way that a member of the single market does. It will take longer. There will be more forms to fill in. There will be more inspections and checks. In some businesses, that will be, if not impossible to deal with, then very, very difficult to deal with. For example, if you're dealing with live seafood, it's very difficult to encompass that within the time that is required to be taken. Now, of course, some of that will be exacerbated by trying to get used to the new procedure. So you could, I think with some confidence, expect that it won't always be absolutely as bad as this. But then, of course, options also change. If a company in the EU is, for example, exporting to the UK as a small part of its market, and it becomes difficult to do it, and there are alternatives, those alternatives will be found. It is much harder for one country out of 27 to do that, but all of the 27 can make those choices. So substantially, the change in relationship is the problem. And the UK will have to get used to a different relationship. And that some of that is also being hidden by the fact that we're in the pandemic. I mean, I believe that was the intention of the UK. That's why they didn't go for an extension of transition, to hide this away. But we haven't seen anything, for example, about increased difficulties for travellers at borders, because people haven't been travelling. And I think, if this had taken place in normal times, we would have seen very considerable dislocation too in that. And people haven't had the experience of, for example, being on holiday within the EU and the changed status and issues that may arise from that, from things like mobile phone roaming. So there's a lot still to come on this. And finally, I would say, Convener, I don't want to prolong this, but finally, of course, some changes are still to come, because we are still in a period of grace, even though the grace period is not being talked about. There are changes still to come in the spring and in the summer that are going to make this harder.
Thank you. Cabinet Secretary, the way the trade and cooperation agreement works, if I understand it correctly, there are constraints brought about by the level playing field requirements covering subsidies, tax and competition, labour, environmental standards, but no recommitment at this stage from the UK government to maintain alignment with EU rules. In the event that there is a serious divergence by either side from the level playing field, then there are rebalancing measures in the agreement that I understand. Given this and the impact of the UK internal market policy on divergence across the UK, what do you think the effects will be on Scottish Government's policy choices in devolved areas? And in reality, the level playing field arrangements, what do you think in your view this means in practice, and what might it look like?
Well, Convener, you could hold a complete inquiry into that one subject. I think this is going to be a dominant issue in the next Parliament, because you're right to say that essentially the freedom of action exists for the UK, but there are consequences in its relationship with the EU. And, that's perfectly understandable. And this was a conscious choice by the UK to do it this way. So I think how that then affects the exercise of devolved powers and the freedom of action of the devolved governments is going to be profoundly influential on what those governments actually feel they can do. Then if you then look at the possible constraining effect of the internal market, a very likely effect, unless we can defeat that in the courts, which I think is still a possibility, then you're going to have very severe consequences. And I think it's your successor committee is going to have to look very carefully at that. Now, if you put that alongside what is an active agenda to diminish and undermine devolution, there can be no doubt about it now. I mean, that's exactly where it is. Then I think you are going to see a very, very serious set of circumstances arising in the next Parliament, which will require substantial action. And I won't labour the point. My preference. It also, I think, it's no secret to know it's your preference. You can choose between a constant diminution of and undermining of devolution, or you can choose or independence. That's your choice.
Thank you, Cabinet Secretary. If I get time, I may come back and ask a question around the fiscal framework, but we'll see where we are. In the meantime, can I go to Murdo Fraser, please?
Thank you, Convener. Good morning, Cabinet Secretary. And as you said, this might be the last time you appear in front of the committee, so can I just say how much I enjoyed our exchanges and how much I'm going to miss them in the future. Can I ask you about the issue of common frameworks? You very helpfully wrote to the committee on the 8th of December with a summary of where we are in relation to the common frameworks. It is clear that with the pandemic, there has been some delay in putting these in place, but progress clearly is being made, particularly in relation to the issue of stakeholder engagement and scrutiny by various parliamentary committees. The point is made fairly, I think, in your letter, though, that we are facing something of an issue in terms of timing, because with Parliament rising just in about a month's time, and the new committees of Parliament will not be formed until well into May, and in practical terms, I think we realise that it's usually into September before committees really get their work programme underway. We're looking at a gap of some months before further work can continue. So I'm really just interested in any thoughts you have about the timescale for this work to progress and what that means in practical terms.
Yes, and can I also thank you for your kind words. I hope this exchange is going to live up to the high standard that we have set ourselves over many years, I have to say. I'm pleased to say that three full frameworks have been to relevant lead scrutiny committees: nutrition labelling, composition and standards, hazardous substances, and food and feed safety and hygiene. Now, all the others, and I don't have to hand the exact list, but all the others have been agreed for remaining policy areas provisionally. And that means signed off by portfolio ministers across the UK government, Scottish government, Welsh government, the Northern Ireland executive, with two exceptions. There are two that haven't yet been signed off by the Northern Ireland government, and that is nothing to do with their content, I'm assured. It is to do with process. So the process is complete in terms of them existing. Their scrutiny by committee still has to take place. So they can operate essentially as if they were fully in existence, but they do require further scrutiny. Now, that's to be regretted. You're right to say pandemic and other issues have affected that. I think the question then is, would there be any lacunae, any moment at which the lack of these existent would be a problem? I don't see it. I don't know of any such circumstance, and no such circumstance has been drawn to my attention. Were that to be the case, the framework could operate in provisional form. So they are there and they are essentially available, with the exception of two that haven't been signed off by ministers. And I think that is going to happen. In my view, it's just a matter of a process.
Okay, thank you for that response. To an extent, you've preempted what was my follow-up question, which was, I mean, given that the frameworks are not in place, we are in a lacuna at present. And given that there would only be an issue if there was divergence in terms of regulations in different parts of the UK, is there in effect a self-denying ordinance in place that would prevent any divergence pending the final completion of these common frameworks?
Well, I don't want to bandy words, but I think it would depend on what you mean by prevent. The reality of the situation is we have entirely accepted that there should be negotiation on these matters from the very beginning. So, were Michael Gove to say to me, here is an issue which requires the operation of frameworks and we have a disagreement on it, the attempt would be to sit down and find an agreement on it. I think that you would then say, does prevent mean that somebody could say at any stage in that process, no, sorry, I'm just imposing what I want? The only people who could do that are the UK government through the Single Market Bill, and that would be, that would lead to a breakdown in the operation of the framework, because we've said that we would not operate frameworks. So, to the extent you call it self-denying ordinance, I think relying on the frameworks is the right thing to do. There was a step towards that in the House of Lords amendments to the Internal Market Bill. Eventually, I still think it's best to rely on them completely. I can see no reason why they shouldn't do so. And therefore, I would, rather than a self-denying ordinance, I would commend restraint on part of the UK government on these matters.
Okay, thank you. I'm sure restraint is always commendable. And I suppose just my final question then, and members of this committee have spent a great deal of time over the past couple of years looking around this issue of common frameworks, and we've produced a number of reports. And one of our key recommendations was always that the common framework should be agreed between all the parties and would not be imposed by the UK government. It does sound like what you're saying, that hasn't happened, and these have actually been reached by negotiation and agreement.
Absolutely, and that is why I believe they should be relied on, and that is why I believe the Internal Market Bill was a foolish thing to do, to be honest, because it disrupted that process. And I hope that could be put to one side. And regrettably, that wasn't a decision of the UK government and its supporters, but it might be the decision of the courts.
Okay, thank you, Convener. Thank you, Cabinet Secretary.
Thank you, Murdo. Can we go to Tom Arthur? I know Tom's got a couple of areas you'd like to cover. Issues around consent and also musicians, but we'll come back to musicians later on in the evidence session. Tom.
Thank you very much, Convener, and good morning, Cabinet Secretary. I really, at this stage, just a specific question around consent in the Internal Market Act. When the Chancellor of the Duchy of Lancaster, Michael Gove, was in front of the committee back in September, I pressed him around the issues, and I think it's Schedule 2, what services will be exempt from mutual recognition. At that stage, the bill contained provisions to allow that list of exempt services to be modified via statutory instrument without any engagement with devolved authorities, and indeed there was also a temporary made affirmative provision within the bill at that stage. I understand that they have now been they were removed prior to the passing of the bill. However, what has now been put in place is been described as a consent mechanism that, and this is at section 18(8) and 9 of the Act. But my understanding of this is that this what's been described as a consent mechanism is not really so much a consent mechanism. It just effectively obliges UK government ministers to give 1 month's notice of their intention to use the powers, because there actually is no need to obtain consent from any of the devolved administrations. If I missed something, Cabinet Secretary, is that a fair understanding?
No, I think it's a reasonable understanding. The issue of consent has been at the heart of all the discussions that I've had over the almost last 5 years with the UK government, and it's a very simple issue, which is devolution is a delicate dance around the issue of Westminster parliamentary sovereignty. Now you can dispute Westminster parliamentary sovereignty and the understanding of sovereignty that the UK government currently has, and its heavy reliance upon that. But if you believe those things, then you don't believe in the end that the Westminster Parliament can be gainsaid by anybody else, and certainly not by the devolved governments and the devolved parliaments. So in these circumstances, the word consent is perhaps not as accurate as it should be. It's like legislative consent motion. If you give consent, if you refuse consent, but it's still taken, then the word consent is devalued, and maybe it's not the right word. So you're right. I mean, essentially telling people you're going to do something in the hope that they will eventually say, well, okay, then that's fine, isn't a mechanism for consent. There is no requirement for them to say, this is what we're going to do, and we're going to say, no, you're not. And then, we can have a discussion about it. And this also, when we come to discuss the internal, the internal governance and the review of the internal relations, is a major issue.
Yeah.
Can I ask?
No, you go, Tom. Sorry.
No, the question I wanted to follow up with, Cabinet Secretary, is for all of it will be further reviews. Ultimately, this, as with everything within the unwritten British Constitution, it comes down to convention, doesn't it? Because ultimately, there can be no meaningful consent while the concept of parliamentary sovereignty, the Crown in Parliament, exists. There could only be a meaningful consent mechanism were there to be a written constitution that was independent of Parliament. Do you think there is a possibility for any meaningful consent mechanism to exist for devolved legislatures across the UK, where we still have the concept of parliamentary sovereignty predominant at Westminster?
Well, I don't, because I think we've seen in reality for a long time how it operates. Now, to be fair, if you look at the view of the Welsh government, and Mark Drakeford has been very thoughtful about this. Mark Drakeford and the Welsh government have published material that indicates that they see a way in which sovereignty would be held by each of the devolved administrations, to all governments, and they would freely pool that sovereignty amongst the four nations, so that we would all say, look, we were responsible, the sovereignty was here, we were pooling that and taking part. I suppose you could construct that as federalism of some sort. I don't see any willingness by the UK government of any hue to move in that direction. And it seems to me then it is absolutely stark and clear that you either accept a system in which you can always be overruled, and it didn't happen for the first decade and a bit, maybe 2 decades of devolution, but it was still a potential. And then a UK government arose which said, oh, well, we can do what we like. I mean, with impunity, we can do what we like. And that is what we are now seeing. And that seems to be, in the end, not tolerable and not stable. And therefore, we need to move into a different dispensation. Otherwise, this just will happen again and again.
Let me ask one final question at this stage, Convener, and I'm conscious I don't want to overplay the valedictory air to this particular committee meeting, given it's slightly through the Cabinet Secretary's last appearance. However, can I ask the Cabinet Secretary to reflect upon his tenure over the last 5 years and how his understanding of Scotland's place within the UK and the relationship between the devolved governments and the UK government has changed and developed? Has he been surprised or shocked, or perhaps has it confirmed views that he already had? Is there anything that he knows now that he would perhaps have found difficult to believe or predict 5 years ago?
Oh, I think it would take me far too long to answer that. I can simply say that I don't believe that the constitutional settlement under which we presently live, it can continue to exist for a long period of time, because it's inherently unstable. And I think there is a clear choice for the people of Scotland to have. I mean, that's not a great surprise to anybody. I think my disappointment is that I had hoped that there would be a rational approach to this, and there hasn't been from the UK government. There's simply been a power play by the UK government consistently and solidly, in which they know they can get away with things, and that has been a huge disappointment. I do think the one thing I would say to you, Mr. Arthur, is I do think at the very start of the Brexit process, and I've said this many times, and it's not an original thought, I think it arose with a journalist who wrote about it about 2 years ago. If Theresa May had put everybody in the same room in Downing Street very early on, as she tried to do but then wasn't listening, and said to the leader of the Labour Party, Liberal Democrats, to the First Ministers of Scotland, Wales and Northern Ireland, and said, look, we all need to get something out of it. How can we compromise on this issue of Brexit so that everybody feels they've got something? We could have avoided the bitterness, the unpleasantness and the sheer damage that has been done. But it became a right-wing ideological fixation that they had to deliver something, the hardest of Brexits. And that has led to the huge difficulties that we presently have and will continue to have, because the form of Brexit is the hardest Brexit. I wouldn't have supported Brexit of any description, but it was possible to have a compromise in 2016, early 2017, and that did not happen.
Thank you.
Can we go to Patrick Harvie, please?
Thank you, Convener. Good morning to the Cabinet Secretary. I'm continuing with the issue of consent, which you've clearly set out your own view that the concept of consent is problematic. I think everybody would accept that it is at least contested in terms of what its meaning is. But things have changed, partly with the UK Internal Market Bill introducing additional elements of consent into the relationship, and partly with the recent history of major legislation being passed which affects and constricts devolved competence without the consent or against the refusal of consent of the Scottish Parliament and other devolved jurisdictions. Toward the end of last year, the Welsh Government announced that they were going to initiate a legal process. Jeremy Miles on the 16th of December, said, "We have today formally notified the UK government that should the UK Parliament enact the bill, the Internal Market Bill as it was then, in its present form, I intend to take immediate action to seek a declaration from the Administrative Court that the ambit of constitutional legislation cannot lawfully be cut down in this way, and that the ensuing Act cannot be interpreted so as to have that effect." And I think on the same day, you indicated that the Scottish Government would support and stand with the Welsh Government in that action. So can you give the committee an update? What has happened since the 16th of December in relation to those issues? How actively is the Scottish Government engaging with the Welsh Government on that potential legal process? And what are the intentions going forward of the Scottish Government should your colleagues continue to form the Scottish Government after May?
Yeah, happy to do so. Jeremy Miles did make the announcement in December. I was aware of it and spoke to him very shortly afterwards. Made it clear that the Scottish Government would support them in that action. They issued a letter in advance of action at that stage, I think that day, to the UK Government, had a response, and on the 19th of January, the Welsh Government commenced formal legal action, which is seeking a judicial review to test the legality and principles of the UK Internal Market Act. The Welsh Government now has to seek permission to proceed. It has applied for permission to proceed. That has not yet been granted. I understand the UK Government's answers to this initial step, have now been lodged, maybe lodged at the end of last week. And the court will then decide upon them. I think the Welsh wanted an expedited process that hasn't been granted. So we've continued to liaise with them on that. We've indicated that should they get consent to proceed, then we will take an active role, whether we join in the action or take some other step. I don't think we've decided yet, but we will take an active role and we strongly support it. But we're not at that position as yet. But we will stand beside, in lockstep with, alongside and in support of the Welsh in this process. And we also reserve the right to consider other actions ourselves, and that is an active process. But I think we decided that we would just see what happened with the Welsh action first before we took any actions ourselves.
Having decided yet what the nature of the Scottish Government's active role will be, when do you anticipate that decision being reached?
Know whether they have permission to proceed, because then our choice is very clear. Do we join ourselves to the action or not? And certainly, my view is that we should join ourselves to the action if they have permission to proceed.
Finally, on this, unlike Tom Arthur, I take the view that it would be possible to have a clear legal definition of consent. And of the exemption not normally, which usually applies to consent. It would be possible to reach a clear legal definition which would constrain the actions of UK ministers and which would properly interpret legislation in the courts if there was conflict or dispute in the future. It's perhaps not for those of us who want Scotland to be independent to demonstrate for the convenience of others that consent could be properly legally defined. But do you see, as yet, any interest from those who are seeking to persuade the people of Scotland that the current constitutional arrangements are appropriate? Do you see any interest in achieving a change that would properly define that concept of consent, which ultimately is fundamental to the relationship between Scottish popular sovereignty and the sovereignty of the UK Parliament?
No, I see no willingness to accept that. I think it's tied very closely to two other things. One is the recognition of the people of Scotland decide to that they wish to vote on their future, they should be allowed to do so. And if you deny that, then you're getting yourself into all sorts of extraordinary hot water. And it seems to me that if you don't accept that, and you don't accept that there should be an element of equality and equity and consent, then you're in a very difficult place in terms of being able to. We're in a difficult place to negotiate with people who just don't accept either of those two norms. And therefore, it does seem to me that unless you were to, well, the other thing it's tied to, and I've quoted before at this committee, and let me do it again, a remark that the then Taoiseach, Varadkar, made. I remember making it at the British Irish Council about what trust was. And he said trust between the nations in the EU was based upon the fact that it was legally enforceable. If you fell out about something, there was a framework of law, through the ECJ, through the arrangement they have, that you could appeal to. Now, if you have no framework of law, if you don't believe in popular sovereignty and the rights of people to make decisions, it's pretty difficult to have a conversation about how we could move this stuff forward, because you're not doing it from any principle or any firm ground at all. So, I suppose that's a very long way of saying, yeah, it is possible to envisage a formal constitutional structure that does guarantee consent. But I think the current UK government, previous UK governments, and most likely future UK governments haven't a Scooby about how they would do that, nor have they any desire to do it.
Thank you.
Thank you, Patrick. We now go to Fulton McGregor, please.
Thanks, Convener. Good morning, Cabinet Secretary. I was actually reading an article this morning that the BBC are running, I think it might be BBC Wales, about concerns that EU citizens eligible to stay are at risk of slipping through the net at the current time, and I think it's to do with difficulties in getting support with completing applications. And the campaigners there are actually warning of a Windrush Plus. Is this something that's a worry here in Scotland? Is it something that the Scottish Government have picked up on? And can also ask if you could comment on, I know we're in a pandemic just now, but future travel arrangements for EU nationals?
Well, Mr. McGregor, it's a very appropriate question. I mean, I am aware personally, certainly of one case in my own constituency of somebody who perfectly legally is in Scotland, but because they're comparatively recently in Scotland and because of the pandemic, are finding it difficult, for example, to get a national insurance number, to get an appointment, to ensure that they can be assessed for the suitability for a job. They've got a job lined up, but the job centres being very slow in processing them because of the pandemic. So I think there's a number of things that have come together that are making it difficult for some EU citizens. There's also continues to be an insecurity because people don't get a physical piece of, document that says they have settled status. I mean, I think it's all highly unsatisfactory. We, as a government, and my colleague Jenny Gilruth, of course, has got responsibility for migration and EU nationals. As a government, we continue to first of all, to try and keep EU nationals informed. Secondly, to look at individual cases as they arise and to try and help out in those cases and to see if we can provide assistance. And of course, we've supported the Citizens Advice Bureau in making sure that they are a place where information can be had. And I would make that point that we do try and make sure that the information is available through there. And also, in terms of the structures under the withdrawal agreement, there are structures that are meant to look at, not at individual cases, but the generic issues and how they're being handled. And we are making representations there and trying to have contacts there. But it is highly unsatisfactory, and and it is so unnecessary, because the EU citizens in Scotland and in the UK are vital parts of what we do and are very, very welcome indeed. And it's just an utterly unnecessary and unpleasant thing to have happened.
Yeah, thanks for that, Cabinet Secretary, and I do appreciate the work that the Scottish Government are doing to keep EU citizens informed, and I do think this is an area that we'll continue to need to stay on top of, particularly as we perhaps come out of the pandemic as well. I want to turn to my other line of questioning, Cabinet Secretary, and my final one, Convener. It's on Erasmus, and obviously we know that we've got the news that Scotland's bid to remain in the Erasmus scheme unfortunately hasn't been successful. As we're not an independent nation. This has obviously been a very positive scheme for us. Do you think that the Turing scheme that's been put in place by the UK government has got the capacity to match up to Erasmus? Is it likely to to match it or exceed it, or do you have real concerns about this and that we're really going to be losing something for our young people?
Well, I wouldn't give up on Erasmus yet. I mean, what the President of the Commission said was factually correct. It is up for, it is for nations to be in part of this. This is why, Jeremy Miles and I particularly pressed, the UK government so hard through the JMC process to ensure that, there was representation, that the UK stayed in there, or the UK wasn't going to stay in. Arrangements were negotiated to allow a UK membership to devolve to the devolved administration. So that would have been, in my view, negotiable. And I'm surprised, well, not surprised, but disappointed it wasn't negotiated. So let's not give up. There may be all sorts of possibilities we can look at, but it is a loss. It's a substantial loss. The Turing scheme does not deal with youth work and with youth issues, which is a huge part of the Erasmus Plus scheme and very, very important to Scotland. We have not been, there's a process now of telling people essentially what it's going to be about, but there's been no meaningful consultation about what it should be. I mean, even right down to naming it, this thing just appeared. Now, clearly, work was being done on it, and we were not being told about that work, which doesn't give you huge confidence in it. So, I would want to continue to argue. We've got lots of friends in the European Parliament who are very, very keen that we continue to have some association. We can see Ireland is taking Northern Irish young people under its wing, and they will be associated with the scheme through Irish institutions and organisations. We need to continue to think about what we can do. But it is, I mean, two things are shameful about it. It's utterly unnecessary. We could have remained part of it. And it's ridiculous it wasn't, but also the manner by which it was done. The UK government knew perfectly well the view of the devolved governments on this matter. And, we were not told the truth about it. We were not told that this was, that we were never shown the value for money assessment that was undertaken. And right up until virtually the end, we believed that the UK government was intending to stay in, or at least trying to stay in. It was shocking.
Okay, thanks, Fulton. Dean Lockhart, please.
Thanks very much, Convener, and good morning, Cabinet Secretary. This might be our final exchange at committee, but I look forward to our debate tomorrow on the Citizens' Assembly. My question relates to the Scottish Government's plans for keeping pace under the EU continuity legislation and parliamentary scrutiny of how that power is exercised. In response to an FOI request on the 23rd of December, the Scottish Government confirmed that internal impact assessments would be prepared in relation to keeping pace with future EU laws. But as the Cabinet Secretary will recall, this was something that was rejected as formally being part of the legislation. I requested for impact assessments to be part of the legislation, but that didn't make it to the final bill. Will the Cabinet Secretary publish these impact assessments if they are prepared by the Scottish Government so that they can be scrutinised by the Scottish Parliament? And the second point that came out from the FOI response was that the Scottish Government will also undertake consultation on keeping pace with EU laws with bodies such as the European Movement, but no mention was made of consultation with trade bodies such as the NFUS or CBI or other trade bodies. Again, this is something we tried to get reflected as formally being part of the legislation, but it was rejected. So again, if the Scottish Government plans to consult with groups like the European Movement, will the Cabinet Secretary also undertake to consult with trade bodies such as NFUS, CBI and others?
Well, I can assure Mr. Lockhart and set his mind at rest that no consultation would be complete without ensuring that the right people were consulted. So I'm absolutely certain that if an issue affects, for example, agriculture or environment, then it would be inconceivable in my view that NFUS was not consulted. So I don't think you need to worry on that score. As to publication of assessments, I think unless there is a reason for not publishing them in terms of confidentiality or whatever, I can't see any reason why they shouldn't be published. Indeed, I would think they would be FOIable in any case. So I don't think anything's going to be done in secret. We have not yet moved to use the Act, but when we do use the Act, as I'm sure we will use the Act, then it will all be open above board and according to the legislation, and will even go further. So despite the fact that the amendments that Mr. Lockhart did not want, we are nothing if not helpful. So therefore, I'm quite certain he will be satisfied, or a reasonable person, which I'm sure he is, will be satisfied about how we approach this.
Cabinet Secretary. Thank you. I'm now off mute. That undertaking for transparency is welcome, Cabinet Secretary. You, to some extent, anticipated my supplementary question, which relates to whether you have any plans, or do you anticipate in this current term of Parliament to use the keep pace powers in any respect?
I have no current plans. I don't rule out using it in this term of the Parliament, but I have no current plans to do so. But should we decide to do so, I'd make that very clear early on. But as of today, I have no such plans. But I'm not absolutely going to rule out using it just in case.
Okay, thank you. My final question relates to EU structural funds. I think that John Mason is going to ask about the UK Shared Prosperity Fund, so I don't want to preempt his question on that. But I do want to ask the Cabinet Secretary about how EU structural funds have operated over the past couple of years, because my understanding is, based on PQs, responses to PQs and the SPICE briefing, the level of EU structural funds have been reduced in recent years by approximately €70 million. And the reasons given for that, as I understand it, are that it reflects underspend by the Scottish Government, it reflects some non-compliant bids for EU funding, and overall it reflects the sort of complexity which this committee and other committees have heard about in relation to how the EU structural funds operate. But I just wanted to hear from the Cabinet Secretary, what's your understanding as to why those EU structural funds have been reduced in recent years?
Oh, a very complex issue, European structural funds, and that is one of the problems. So I could not glibly tell the member why there has been any sort of reduction. I would need to see all the figures and to understand them. I've been dealing with EU structural funds for many, many years in many different guises, and I am aware that there are many reasons for an individual project, for example, not proceeding, an individual project being delayed. So I think we need to look at that in some detail. In terms of simplicity of operation, I agree with Mr. Lockhart that we need very simple procedures, and I've constantly argued for simpler procedures, not just in funding, but in a variety of other things over the years. So I'm sure you will forgive me a slight scepticism that the UK government will be able to operate simpler procedures. That's not been my experience. But I do hope that whatever happens with this, that we have simple and approachable procedures that make sure money flows, and that the money flows at the level or above the level previously, because there should be no detriment. And I hope we would all sign on to detriment and insist that the monies are, first of all, at least match, if not exceed, previous budgets. But in addition, are undertaken and spent with the fullest of consultation with all the interested parties, which I suppose reflects back to his previous question, those parties, of course, up to and including the Scottish Government.
Thanks, Dean. It's grand we have agreement between Dean Lockhart and the Cabinet Secretary. It's just a pity we don't have enough time left in this Parliament to make it become a habit. With that said, Alistair Allen, please.
Thank you, Convener. I want to ask a little bit more about intergovernmental relations and the structures that are there for that. You and I have both served on joint ministerial committees, and I think it's fair to say those are hours of our lives we'll never get back. Can I ask that you could explain a bit to perhaps people watching who don't know how intergovernmental committees work, how the agendas for these committees are set, who chairs them, and how effective, in your view, they are as organisations and institutions?
Yes, I mean, you have suffered the JMC process as I have suffered it. There have been to date, let me just use the JMC European negotiations as an example. There have been to date 28 meetings of the JMC-EN. I have been at every single one of them, regrettably I have to say, but I have been. Of those, only 2 were chaired by non-UK ministers, and this was a real innovation for the JMC. I chaired one in Edinburgh, I think in October 2019, and I think the Welsh First Minister chaired one in Cardiff in the end of January 2020. So 26 of the 28 meetings were chaired by UK government ministers, and in terms of the location of the meetings, all but those two were held in London, with the exception, I think, of two that were held, possibly three, in the margins of the BIC, the British Irish Council, because we all happened to be there. The agendas are ostensibly put together by a JMCO, that is the officials group, but in fact, it is what the UK government wants to be, and the agenda papers, do not turn up until the very last minute. Sometimes don't turn up. I was famously at the famous group of issues that were joint competences between the UK and the EU and the devolved administrations. We turned up at the meeting without having seen the paper, and the discussion started, and we still hadn't seen the paper. So things are chaotic. The JMC is not a meeting of equals. It is not a decision-making body, and even the JMC-EN, which had an agreed remit, just essentially allows the UK government to say what it wants in the way it wants and to behave in the way it wants. And great store has been put by certainly the May administration and the Johnson administration that these are in some sense significant moments in involving the devolved governments in decision making. That is simply not true. The more meetings there were, the less that people got to know. And you have been, for example, at JMC Europe meetings, which no longer exist, which are the same. And I suppose the final thing I would say about it is these committees can be lifted and laid by the UK at will. The JMC plenary, the Memorandum of Understanding that governs this, means it has to meet at least once a year. It has not met since December 2018. I think I'm right in saying. The JMC-EN may not now exist. I don't know, is the answer. The view of the UK government was that it had ceased to exist once on December the 31st. There has been no subsequent meeting and no replacement for it. The last meeting, I think, was on the 28th of December. I had to resist very firmly the view of the UK government at one stage that, for example, intergovernmental review should be removed from discussion at the JMC-EN, and there should be some separate arrangement for it, which wasn't specified. And I think they sent Oliver Dowden, who was then the Cabinet Office Minister, to see me to tell me this. And I had to say to him, well, this does not belong to the UK. This is a shared responsibility. But I don't think the point was taken.
Thank you. That does all sound horribly familiar. I do recall one meeting where we didn't get the papers until the night before, and it turned out that the paper was on the subject of how to involve the devolved administrations more effectively in meetings of the committee. So it doesn't sound like much has changed, but obviously there have been proposals for change from both Wales and Scotland, and you've touched on those already. Do you feel that there's any scope for some of these things progressing? For instance, Wales and Scotland have talked, as of you today, about respect for legislation passed in the devolved legislatures. You've mentioned dispute resolution mechanisms. What I'm not quite clear on is whether you feel that in the future these things are going to actually be progressed in any meaningful way.
I am very sceptical as to whether there is an intention to make the system work in a way that would be equitable. But we have taken part in the discussions about a new intergovernmental system. Those have been, I think May would mark the third birthday of those discussions. But it wouldn't be impossible to reach an agreement. In my view, it does not compromise independence to be able to continue to operate in a way that is at least not detrimental to the devolved administrations and to the UK government by having some sort of formal structure to work together. But we are, in my view, pretty far away from a resolution. There are a number of sticking points. One of them is the role of the Prime Minister. I mean, the current proposals seem to eliminate the Prime Minister as being above everything. That was never the intention of the discussions. The JMC plenary, consists of the Prime Minister and the leaders of the devolved governments, and I don't think that can be avoided. I suppose the most significant one is this perpetual issue of the UK government being judge and jury in its own cause. And that's particularly important in finance. When the DUP received the £1 billion bung, both the Welsh and ourselves objected under the existing structures and said this should not have happened without this sum being Barnetized and money coming elsewhere. And of course, what we got was a decision by the UK government via the UK Treasury to say nothing to see here, move along, please. But that was the decision made by the people who had done the payment. So it really just is not feasible. There has to be a system of equity and an independent element in any dispute resolution. And if that is not accepted, then there's no point in having a new agreement, because it is as flawed as the old agreement.
Finally, Convener, I don't want to suggest for a minute that the structures that I'm talking about and you're talking about could in any form have dealt with some of the fallout from Brexit, but you and I both represent Fishound constituencies. Do you feel that the joint ministerial committees have engaged in any meaningful way on some of the problems that have resulted for fishermen in Scotland as a result of the Brexit deal, or has that been something that they've managed to offer any kind of insight into at all?
There was a moment, I remember, in the run-up to the Chequers, the famous Chequers meeting of 2018, was it? Chequers? David Davis told me that he, when I was asking if anything that we've said at any stage made it anywhere through the impenetrable system, he assured me that the points I had raised in terms of, islands, supplying islands, and he mentioned Colonsay in particular, which I had raised, the supplying islands in terms of supply chains and fishing interests in my constituency, he had raised at the Chequers meeting. I have no idea whether he did so or not. But it is obvious that this has not worked and continues to not work. And the current approach of the UK government is to pretend that it isn't happening. I mean, the number of XO meetings, these are the withdrawal meetings, has been reduced and continues to be reduced. So meetings in which a Scottish Government Minister, Welsh Government Minister, UK ministers can at least discuss some of the problems that have emerged and continue to emerge, these are diminishing in number and continue to diminish in number. And the attitude appears to be, again, nothing much to see here, let's just move on. And that is simply not real. And I don't believe you solve problems by putting your head in the sand, but that is what is happening.
Thank you, Alistair. I'll now go to John Mason, please.
Thanks very much, Convener. And I think, as Dean Lockhart was indicating, I'd like to ask where we are with the UK Shared Prosperity Fund following on from the EU structural funds, because it does seem to me that the EU structural funds have been very important for Scotland, and I think in many ways more important even for Wales. And there has been concern on this committee and elsewhere about where we would go with that once we left the EU. So I just wonder if you can give any update from your point of view as to where we are with that now and how it's going to work in practice.
Yes, I can certainly give you the limited amount of information that I have. I think the most significant part of it is to say that it is now clear from the UK government that there will not be a Scottish devolved involvement in the Shared Prosperity Fund. Steve Barclay indicated in a recent letter that Scotland would not be involved and the devolved administration would not be involved in administering the Shared Prosperity Fund. Now, the Shared Prosperity Fund is extremely important. The monies coming to Scotland through the EU mechanisms have been very important. We published in November, as you may be aware, a plan of how we believe that it should operate within Scotland. We've had a steering group of experts. which looked at this and came to a conclusion about how it should operate in Scotland. That has just completely and utterly been ignored. And the UK government is now consulting on the issue of the Shared Prosperity Fund. But it is on the basis that they are going to control that fund and they're going to run it according to their priorities. How you can centralise such a fund, I just do not understand. But they're doing so. We've asked for input. We asked for input into the questions posed in the consultation. We did not get that input. We only saw a draft version on the afternoon before it launched. So there's no genuine intention even to consider the views that are coming from the Scottish Government. The consultation closes on the 31st of March. We will respond as a government before the pre-election period. We will bring forward our own proposals for this. But then, what I would expect is this is just bulldozed ahead presently. And I just do not see how it can meet the aim, which should be to reduce economic and social disparity, not just between the bits of these islands, but actually in Scotland. And, we can and know how to handle that, have handled it, and will handle it. But it seems utterly willful. It's also been incredibly slow. I mean, this money should have been flowing, because there is a huge period between European funds being available and this coming on stream. And of course, we don't know what guarantees there would be of anything like the sums of money that were being spent. So Scotland will be severely damaged by what is taking place, and it is a willful action by the UK government.
Yes, you talked about guarantees and what amounts of money might be involved. And I did ask Ivan McKee previously, were we actually guaranteed any money at all? And he kind of laughed a bit, and obviously he trusts the UK government that they'll give us some money. But have there been any indications as to how much we might get?
And the current 7-year programme of the European Structural Funds is worth £738 million. It's sometimes a bit difficult to be entirely accurate because there are currency fluctuations. There, as Dean Lockhart has pointed out, group programme delivery issues. But let's amongst friends, say around £700 million over those 7 years. There are no such guarantees, and we couldn't enforce those guarantees. So no matter what the UK government says today, and no matter what largesse Steve Barclay promises, frankly, until I saw the £700 million in Scotland, I wouldn't believe it.
Okay, and my final point would be then on the way the money is spent, because, I mean, we might want to, say, move towards more active travel and more, say, investing in railways or even ferries for that matter, and the UK government might favour roads. So, I mean, if there was a kind of tension there, how would that be resolved?
Well, that is a crucial question, and of course it's one of the reasons why there has been no spend in devolved areas by a UK government, and it's entirely sensible when you think about it. It avoids waste because it means there's no duplication, but secondly, it recognises the primacy in devolved areas of a devolved administration. And the intention here is just to ride roughshod over that. Now, it may well be that Alistair Jack wants, a new road in his constituency, but that shouldn't override the common sense of making sure that, devolved areas are the responsibility of the devolved government. But we're not going to see that. We're going to see, frankly, pork barrel politics by Tory politicians. Now, I don't think the pork barrel works in these circumstances, so I think that's wasteful. But I think it will also turn out to be very, very stupid to do it this way.
Thanks, Convener.
Thank you, John. Tom Arthur, please.
Thank you very much, Convener. I wanted just to come back to the Cabinet Secretary on one issue that is very dear to my heart, and I know he cares a great deal about, and that is the impact upon the music sector of Brexit. I appreciate this is perhaps more within the purview of other committees such as the Culture Committee or perhaps the Economy Committee. However, the Cabinet Secretary will be aware from question that I've asked previously in the Chamber, and also from a members' debate I led nearly 3.5 years ago, what were then the forecast impacts that Brexit would have on music about the deep concerns shared by many across the music sector. And I'm sure you will be aware again of many musicians in recent days raising their voices about the impact that Brexit is going to have on their ability to work and to tour across Europe once restrictions are hopefully relaxed as we move out of the pandemic. I just would like to ask the Cabinet Secretary, within the context of the current devolution settlement, what options are available to the Scottish Government, and how does the current devolution settlement limit the Scottish Government's ability to respond to issues created as a direct result of Brexit over which we've had no say, such as the impact on the music sector? And I would just remind committee members that I am a member of the Musicians' Union who have been campaigning on this issue and have a professional background in music as well.
It is very clear, I'm sorry to say, that the power of the Scottish Government to resolve this issue is very limited. The UK government appears to have got itself into a complete mess with this issue. The Culture Minister's evidence yesterday, I think, to the DCMS committee was confused and nonsensical. It is, in my view, quite obvious that this was ideological and was designed to limit, maybe not consciously, but because there were so many of these issues that maybe they just all passed by, but to limit any involvement in Europe from anybody. And it's misfired very badly. The UK government looks as if it's going to have to negotiate, if it can, individual agreements with all the 27 member states, unless the EU itself takes some unilateral action, and there has been some discussion of that. But as a Scottish government, I would love to be able to say, look, here's a letter of passage or whatever that will allow you to just ignore this, but I can't, because we don't have the power of those areas, and that does indicate that if you're actually going to be effective, you should have control of all those areas. The fact that this has been done to Scottish musicians as well as musicians elsewhere and performers elsewhere does, in my view, suggest an inevitable solution, which is don't put yourself in a position where this can be done to you.
Just as a final question, Cabinet Secretary, do you think there is any way to resolve this issue where Scotland remains a part of the United Kingdom, just given that the reality is that the current UK government doesn't want to seem to move on it? I think it'd be very difficult for a government to be elected to the UK Parliament in Westminster on a prospectus of relaxing restrictions around freedom of movement. Do you see any opportunity for Scottish musicians to be able to start working again in Europe freely as they were before the 31st of December without Scotland rejoining the European Union as an independent nation state?
Well, the individual issue may be resolved by the UK or the other countries, but it will take time. It may not be, of course. But the best solution to this, because within the wider context of freedom of movement, is to restore freedom of movement, which requires us to be an independent member state. Freedom of movement has been immensely successful for Scotland. There isn't a member on this committee whose constituency or region has not benefited from freedom of movement. There are no downsides to freedom of movement in Scotland. None whatsoever. And the fact that it has been removed is shocking in both ways, both in terms of people coming here, but in terms of people going out into Europe. Our life chances and opportunities of our young people have been diminished by this and by Erasmus, and the expectations we have of being able to work together have been dashed for no reason, none whatsoever.
Okay, thank you, Tom.
Thank you.
Mike Russell, for your evidence today. You said, and it's probably right, in all likelihood this will be your last time in appearance before the committee. Cabinet Secretary, so can I therefore thank you for your contributions over the last 5 years. And of course, we'll both be taking leave of Parliament shortly, and we'll not get a chance to do this again. But it's been fun.
It has. So, thank you.
That was our only piece of public business today, so I now close this public part of the meeting. We'll reconvene in a Teams format in about 5 minutes at, let's say 10:40. Thank you.
Thank you
very much, and I'll see the rest of the team there very shortly. Thank you.